The Housing Committee on the Social Security Commencement of Benefits Amendment Bill is resumed. Before dinner, we were debating clauses 1 to 6 in a variety of supplementary order papers. Ian Lees-Galloway has the call and has 2 minutes remaining.
Mr. Chairman.
Ian Lees-Galloway.
Thank you very much, Mr. Chairman. Before the dinner break, or immediately before the dinner break, I was lamenting the fact that it had taken the government a year and a half to bring this legislation before the House, all 4 pages of it, and it really does baffle me why it took so long to bring this legislation to the House, and now, after waiting such a long period, it's passing it through all stages under urgency without any opportunity for scrutiny, no regulatory impact statement, no select committee process. What we do have, sir, is the departmental disclosure statement, which I think raises some issues. Questions: Are there any publicly available inquiry, review, or evaluation reports that have informed or are relevant to the policy to be given effect by this bill? No. Were there any regulatory impact statements provided to inform the policy decisions that led to this bill? No. For the policy to be given effect by this bill, is there analysis available on the size of potential costs and benefits? No. The potential for any group of persons to suffer a substantial, unavoidable loss of income or wealth? No. Even though we in fact know that the impact of this legislation is to limit the opportunity people have to seek redress for having lost a portion of income that they were entitled to under law. And essentially just about every question that is asked, the standard questions asked by the departmental disclosure statement, the answer is no. I think it actually demonstrates just how little work has been done to prepare this legislation and to make sure that what we do tonight actually rectifies a situation that was caused by legislation being passed under urgency back in 1998 and the errors that can come with that. Mr. Chairman.
Ian Lees-Galloway.
Thank you very much, Mr. Chairman. I would like to turn my attention, though, to the supplementary order papers. There are 3 supplementary order papers, one in the name of Carmel Sepuloni, one in the name of Jan Logie, and one in the Minister's name. I'd like to start with my colleague Carmel Sepuloni, who the supplementary order, the effect of the supplementary order paper would be to delay the commencement of this legislation by 6 weeks, and that is simply to give people an opportunity to actually seek some redress I think we're particularly thinking here of the people who have been affected by the incorrect application of the law numerous times. And we have spoken about the fact that this, for a lot of people, this won't have affected them just once. And there are many people, particularly those in fixed-term contracts, those who are on casual work, those who are on seasonal work in particular, who will have moved in and out of work many times over the 18 years that this policy has been implemented inappropriately. And for some of those people, we could be talking significant sums of money. For most people, if it's only occurred once or twice, then probably the hassle of applying to retrospectively gain that 1 day's worth of income is probably not worth it for them. But for some people, there may well be some value in making that application. And what Carmel Sepuloni's proposed amendment would do is give people a short window, a very short window, which I think the government could easily work with us on this, to allow people that opportunity to apply to receive the income that they ought to have had the legislation as it was originally drafted been applied appropriately. And I think when I've heard a couple of members dismiss this approach, and I think when they do that, they assume that everybody falls into that category of people who it's only happened to them once or twice. And there will definitely be, not that we know for sure because the government has not been able to provide us with figures, but there will definitely be people who for whom there would be value in exploring exactly how much they are owed by the government and taking the time to do that. Now, Jan Logi's amendment is similar, only it gives a 6-month window. So really what we're debating here is how long is an appropriate length of time for people to be able to make that application. And certainly on this side of the House, we've got no problem with the 6-month window, 6 weeks or 6 months. Either of those would be acceptable to us. Then we come to the Minister's amendment, and this is a really interesting one. So this amendment allows people who have been denied what they were were legally owed under the law during the period in which the government knew it was acting illegally, to be able to retrospectively apply for that, to pick up retrospectively that money that they were entitled to. And I find this interesting. Now, I think it's good in a way that the government is trying to rectify the fact that they were acting illegally, but that nevertheless, it is a fact that the government for a year and a half nearly knowingly denied people income that they were owed under the law, even though they knew that the legislation as it was drafted said they were entitled to something different. Now, we can support that as well, but we don't think it goes far enough, and we actually think that one of those other amendments in one of those other supplementary order papers, either Carmel Sepuloni's or Jan Logi's, needs to be passed if we are to take a principled approach to this, which is people were entitled to some income. It has been denied them. They should be given the opportunity to apply to receive what they were owed. And my suspicion is most people will not. It won't be worth their while making that application, but for a handful of people, it will be worth their while making that application. And I think there is value in supporting those two supplementary order papers on that basis. So I think I'll end this particular contribution at that point.